the part of a junior member of a bar, my lord.
Yes, yes.
Now, my lord, thereafter, my lord had granted liberty to us to file a new writ petition. My lord, that new writ petition is item number 24, same stretch of road. My lord, this undertaking has been given in this matter. Well, based on this, my lord, if this similar order can be passed.
So, who is for the state?
Please state it.
No, no, I am the 17.
24, who is for the state? So it can be tagged together and it can be disposed of.
As I was submitting before lodge. But the affidavit of service. A service has been done.
24, who is appearing?
Only 24.
তাহলে একটা কাজ করুন, affidavit. Is there any?
No private respondents. Same.
Then এই একটু আগের ফাইলটা দেখি. Then who is the authority? Who is constructing the road?
My lord, the same. Respondent number 11.
There is no respondent number 11 here.
Kindly check respondent number 8, my lord. Respondent number 8.
আচ্ছা একটা কাজ করো যে সিন্স ওইটার সঙ্গেই লিখে পরে লিখে ওটা ডাব্লিউটা লিখে রাখো।
May I? Your lordship, may I just verify?
Kindly check, otherwise it will be difficult. এটা ওই আগেরটাই থাকবে, 17টা থাকবে। Affected?
18 months.
Disposal. Mr. Banerjee, in one matter, Mr. Amritolal Chatterjee was there. He was indisposed of today. So I have fixed it tomorrow, sir.
Tomorrow?
Yes.
I was told that at 3 p.m. it has been fixed today.
3 p.m. Oh, I'm sorry. Then
I shall come at 3 p.m.
Please come.
Lord, it has been personally delivered. Stamp is there.
Very good. Thank you very much. না আর একটা ম্যাটারে তো বললেন যে কালকে রাখলাম না। My lord, in 24, my lord,
in this matter, my lord, I am appearing.
নামটা দিয়ে দাও হয়ে গেছে
কি হলো? কি?
17টার একই মাস
ও আচ্ছা।
ওই একই এটা disclose
আমি নামটা
It not. I shall. It has been fixed today at 3 p.m. I shall come. Item number 10, Your Lordship. I have informed Mr. Dinda he is engaged in some other courtrooms. Item 8, the petitioner informed. 24, my lord, I am for the state.
Item number 1724 done. এই 24 এ ওনার অ্যাপিয়ারেন্সটা নিয়ে নাও। Appearing who is for the petitioner?
My lord, in 18, I am for the petitioner.
State my lord.
My lord, this is my affidavit of service, my lord.
নিয়ে নাও।
In-
File an application before the authority my lord that will be considered by
My lord,
service upon the private respondent has been affected.
yes, my lord.
Service upon the
Yes, my-
private respondent has been affected.
Yes, my lord.
Yes, what is your prayer?
My lord, pray to remove or to demolish the unauthorized construction that has been made before the entrance of my plot and on the PWD land. And to inspection may be conducted that I have requested through my representation also, my lord. My lord, representation of 17th December 2024, which is at page my
Who will consider? Respondent number 5, Mr. Abdul. Respondent number 5. Ashun. The affidavit.
this June 2024 upon consideration by a way of a registered deed
So
from
1 decimal of land on 25th June of 2024 in Esplanade.
sorry, my lord.
In Esplanade.
No, my lord. It is in the south 24 Parganas in my lord area. I'm telling you, my
And
lord.
I'm trying to understand what I am asking.
Yes, my lord.
You have purchased 1 decimal of land on 25th June 2024 in Park Street area,
No,
in Dokhineshwar.
no.
So where is the pleading?
There I have not made the pleading.
It appears to this court that the pleading Reading. The court will look to the annexure and pass an order. Sorry.
Your Lordship, may I be allowed to tender apology? Your Lordship, item number 10, Your Lordship was looking for me. Your Lordship, I was engaged before another court. I tender my unconditional apology. I was not.
Very good. No, your other side is here.
Yes, he is for the state.
Your Lordship, I was for the state. Your Lordship, I tender apology. I was not present.
Well, all right, all right.
Your Lordship, in this matter, a very short point, Your Lordship.
Let the file be placed, sir. Item number 10 চাইছেন।
Matter I have got the report from the NHI, which I filed an exception. Nothing has been given by the
Yes.
state. till
Your Lordship,
You have come forward for quashing of the award.
Why I am saying
এদিকে
because
ন্যাশনাল হাইওয়েজ একটা দিন ওই কল্যাণ বাবু ন্যাশনাল হাইওয়েজ একটা দিন Yes, place your case, sir.
this is a legal question and legal point, Your Lordship. Because if the law is very settled now from
Exception you have filed today.
the last occasion I filed.
Oh, last occasion you have filed. Very good.
The law point, Your Lordship, is that my land was acquired in 2010. That is on the face of the record. They have given me the award. In 2013, the new 2013 Act came into force. After this Act came into force, under Section 105, there is a notification. So, Schedule 4 Acts, the 2013 Act, there is Schedule 4 Acts. The National Highway Act is under 7, Your Lordship. From 1st January 2015, if the majority of the land owners have not been paid, or the award has been made after 1st January 2015, I am entitled under 2013 Act. That is my case, Your Lordship. That's the law point. Now, from the face of the record which NHA has given me, I can show it to you that the award was made after 1st January 2015.
You are referring which act?
The initial acquisition was under the National Act 1956.
Yes.
After that, Your Lordship, from 1st January 2013, from the 1st January 2015, the right to fair compensation and transparency. in
Yeah,
acquisition-
Act 30 of 2013 দিন। Thank you. Yes. What are the facts involved? Tell me first.
Facts involved is, Your Lordship, that they have made the award after 1st January 2015.
After 1st January
2015.
2015.
Yes. So once
Just a minute.
Yeah.
Award passed after 1/1/2015.
the precise date is 31st March 2015.
Where from you get that?
That is in the report, Your Lordship, NHA report, page 18. The date of the award is reflected, Your Lordship. The National Highway has given Your Lordship report by way of an affidavit. If Your Lordship kindly takes page 18, the award date is there, Your Lordship.
Page 18.
Page 18 of the NHA report, Your Lordship.
আমাকে একটু ফ্ল্যাগ দেবেন ভাই। Page 18. Which one?
Yes, Your Lordship. After reference, Your Lordship, sir, point number 1,
Huh.
Your Lordship, is page 18.
Page 18, sir.
Yes. Kindly see after reference, Your Lordship, it start with sir.
Huh.
With reference to the above, it is to intimate that the 3G compensation estimate of the following LA case, as mentioned in table 1, below have been approved by the competent authority NHI, excluding government land date of award considered as 31st/3/2015.
Huh.
So the date is clear, Your Lordship, from the NHI report that the award date is 31st/3/2015. And they have calculated my award under the 1956 Act. The legal question is they should reconsider and calculate under the 2013 Act. One right. देखो ना और
So why you are saying that the then Act 30 will apply?
Yes, Your Lordship, because I'll show from their face of the document as well, and it's a settled principle now. There are two situations, Your Lordship. Whenever the land acquisition has started under the National Highway Act, that is not relevant, because in this case it has started in 2010. It's an admitted fact. But Your Lordship, the question which comes is the 2013 Act, this new Act of 2013 came after from 1st January 2014. It was implemented. But for the National Highway Act, it is effective from 1st January 2015. So from the record which the NHA has also supplied, the 2 points are made clear, Your Lordship.
No, Act 30 of 2013 was brought into force on
1st January 2014. But in the case of NHIA, it came into 1st January 2015.
where from will get that?
Your Lordship, the notification is there. I'll show one second. If your Lordship would kindly see the NHA report on Your Lordship.
The act was brought into effect on January 1, 2014.
Yes, but Your Lordship, not for the Schedule 4 Acts.
Schedule 4 of under which act?
2013 Act, Your Lordship. Your Lordship, this is the Schedule 4 Act.
Schedule 4 of what?
2013 Act, Your Lordship.
Let me see, it is there.
আমি তো ওটাই বলছি রিপোর্ট দেবো জর্জের আমি রিপোর্ট না করছি না
Fourth schedule is at page number 74.
জজ সাহেবকে বললাম জজ ম্যাম বললো দাঁড়াও আগে আমি শুনি
Put down.
Lordship, may I draw one thing to your lordship's attention?
No, not now. Wait, he has not completed. Fourth schedule is the national, yes, item number 7.
Item number 7.
Fourth schedule.
So now the benefit has been enlarged 2013 Act.
Just a minute. Now show me in respect of the schedule, fourth schedule act. This has
Your Lordship is on the NHA report. Kindly come to page number 28 once, Your Lordship. The manual has been extracted over there. I have copy of the manual as well.
yes,
28.
yes.
Now kindly Lordship see page 29.
Yes.
Roman 3, Your Lordship.
Page number 29.
Page number 29.
Roman 3.
Roman 3.
Yes, how?
By now, it is also settled proposition that the first schedule and the third schedule of the Act of 2013 shall be applicable to NH Act 1956 with effect from 1st 1, 2015. As such, the following is clarified. This is the NHA manual, Your Lordship. Now, point C states, all cases of land acquisition where the award has not been announced under section 3G of NH Act till 31st December 2014, or where such award has been announced but compensation has not been paid in respect of majority of the land holdings under acquisition as on 31st December 2014, the compensation would be payable in accordance with the first schedule of the Act of 2013.
Very good. Then you have to satisfy. You have satisfied that your award was passed on
31st March
31st March 2015. Then again you have to satisfy that compensation or where such award has been announced, but compensation has not been, in all cases where awards have not been announced under section till or where such awards have been announced. So your case comes under first one.
First one, that they have the majority,
Admitted.
the majority part is not applicable to me.
This is a disjunctive clause is odd.
Yes, Your Lordship.
So you come under, since it has been not award has not been announced till 31/12/2024-14.
Yes.
So year
I should be
2015 Act
Calcutta
will apply.
2013 Act.
Very good. Anything more?
That's my case, Your Lordship.
Your Lordship, I have to call for a report. I have called for a report. It is yet to arrive to me, Your Lordship. Because without a report, I will be unable to do the matter, Your Lordship. The instructions will come through a report.
After hearing you are saying,
Your Lordship, at the first instance only, I tried to point out, Your Lordship. At the inception, I tried to point out. For the benefit of everyone, Your Lordship.
no, Mr. Dinda, you have not sought for to say leave to
Lordship,
file
Your
report.
Lordship, I need, Your Lordship, with utmost due respect, I need.
No, on 10/6/2025 you appeared.
Lordship, I am a party respondent. I have not filed my report. I need not seek leave to file a report, Your Lordship. All I am seeking today, the report is yet to arrive. Once the report arrives, Your Lordship, I will be, because the instruction will come by a report. I am a party to this proceeding.
Mr. Dinda, matter is taken up on hearing on 16th August 2023. Now we are in the month of August 2025, where in none of the order sheets you have indicated that you intend to file a report. Why have not filed report? Even on the last occasion before me, that is on 10/6/2025.
I was not well on
We have
that.
not.
No, I was not well, Your Lordship, on that day. I did not appear. I was not well on that day.
Your name is Debanshu Dinda.
Yes, yes. On that day, I did not appear.
এই উকিল লোকের দেখান।
আমি আসিনি কোর্ট। I can show. I did not come to the court on the last.
Read.
Lordship, no submissions of mine is authority. I don't know who has given the name, but I did not appear. I was not in court on the last day, Your Lordship.
So your name is there. What are you saying?
Lordship,
Your name is there.
Lordship, there must be some mistake on my office part, but I was not there, Your Lordship. All I am seeking.
Mr. Dinda, you were absent on July 16, 2025. But you were very much present on 10/6.
Yes.
You were present on 17/5. You were present on 23/2024. All previous occasions. You have not indicated that you intend to file a report. No, sorry.
As Your Lordship pleases.
Take down.
Well, kindly recorded this portion. my
Very
lord.
good. I'll record, sir. I'll very well record.
portion of the Mausa. Here the majority, my lord, that is annexure page 30 R6. It is not only my learned French Mausa is concerned. My lord is already passed this order in the similar Mausas, my lord. In a similar situation.
Your Lordship, my contention is not that, Your Lordship. The payment will come only after the award has been passed, as they have specified, Your Lordship.
It is an admitted fact.
As specified over there, Your Lordship, the cut-off date has to be considered. And the majority comes into next question, Your Lordship. In my case, the award has been passed after 1st June 2015.
My lord, kindly give me lordship's some time. I will place lordship's order.
I can recorrect.
My lord.
Bill number.
This further section 30 and 30 simply that in respect of the land acquisition areas compensations were discussed prior to the cut-off date.
My lord, kindly see page 626, my lord, of my report.
I will end up.
Further summary the three
Recollect that, madam.
Well, I am tendering my apology.
No, it's all right.
Exception, my lord, I ought to have been.
Settle, I have decided. A judge cannot take a contrary view. Call the next matter. Mr. Pal, any matter?
This matter, my lord, I am appearing for the respondent 125, railway 50.
Item number 19 or 18?
19.
Who is for the petitioner?
My lord, there was a direction also upon them. May I specifically invite your lordship to a lordship's order dated
Last order.
10th July 2025, last order.
Correction has been done.
Nothing, we have not received any amended cost title or my lord, anything
Correction
like
has been
that.
done.
They are challenging some eviction notice by the railway authorities, and that was due to be taken on 15th July, 25th July.
Umar Farooq Gaji.
In fact, my lord, this writ petition is not maintainable at all. And that is the main reason that.
None appears on behalf of the lead petitioner. Take down.
My lord.
Paragraph
lord,
number
kindly-
hai amar.
Hello.
20, my lord, I beg to appear for the petitioner.
Who is for
Or
the
on the earlier occasion, my lord, the service with regard to the private respondent was not complete. My lord, thereafter, my lord, I again served them. My lord, this is the affidavit of service that confirms service. And the earlier, also, my lord, occasion when I had sent the postal article, that has also been received.
Preliminary point, my lord, is this, my lord, the filling up of a pond, my lord. How the petitioner is affected, my lord. Let it be, my lord, placed before the appeal court, my lord. Public interest litigation.
My lord, my learned senior friend is on the maintainability. My address, your lordship.
এখানে বলছি না, appeal court. এই কোর্টে হবে না বলছি।
My lord, this is very.
How you are going to be affected, sir?
Yes, kindly takes, my lord, paragraph 2 and paragraph 3 once. Paragraph 3. My lord, the petitioner states that Taposh Base, the private respondent herein, is the petitioner's neighbor and owner of a water body situated at such and such. The said water body is an integral part of the local ecosystem as various fish and water species grow therein. Thereafter, what I have said, the petitioner as well as the other adjacent plot holders are using the said water body and has become an integral part of his life. Now, my lord would kindly take, my lord, this issue, whether when I am
interest of the public,
my lord, may I just, my lord, I am not a stranger, my lord. I am a resident of that area, and my lord, I am a neighbor. I am using that plot of land, the water body. My rights are directly being affected. Now, this issue as to
But
the
you,
locus.
you are not the co-sharer of the water body.
No.
Then
No, but definitely, my lord, I am the adjacent plot holder. Adjacent plot holder of that water body. Now, I am using that water body. I might not have that right to do not have the title to use that.
Therefore,
But
it is the public interest litigation.
No, my lord, I'll tell your lordship. This issue whether
Interest of the
it is
public.
একটু বলে নিন। My lord, this issue whether I have a locus in an article, an application under Article 226 of the Constitution of India, my lord, has gone extensively by our division bench, which has held that even if I am a resident and where there is a blatant violation by the revenue, the concerned authority, I can attract the jurisdiction under Article 226 of the Constitution. My lord, kindly takes this judgment once.
go before Mr. Bandyopadhyay is absolutely right.
But kindly takes this judgment.
Have you got any easement right over that water body?
But I am been using that. Therefore, my lord, is an easement right because I've said that I am.
No, you don't have any easement right.
But kindly takes this judgment once, my lord. Kindly take.
No,
This entire issue has been gone into. Okay.
Now go.
My lord, kindly takes first paragraph 23, my lord. Here the question was of an unauthorized construction.
20.
Paragraph 23. This was primarily two issues have fallen for consideration. The second point that had come before whether the petitioner has locus standi to file and maintain the writ petition. Now, this was in relation.
It is regarding raising of a building without sanction. That must have a direct effect upon the neighbor.
Yes. And here also, my lord, the pond adjacent.
Sir, I'm telling you, I reside in a two-story building. If in compliant violation of the building rules of the Kolkata Municipal Corporation, if my neighbor raises an 8-story building without leaving his statutory side space, etc., you have a right to approach. But yeah, you don't have any right.
And I tell your lordship, the honorable court has gone to the extent that even if I am not the neighbor, I am a resident of
For
the same.
that reason, the public interest litigation.
No, my lord, this issue has been gone into. My lord, kindly takes, my lord, paragraph.
No, you don't have any right.
My lord, kindly
if
takes
it is
would it be my lord's kind sanction to transfer the case for as a public interest litigation? Yes, very.
Yes. Before my court, you please come ready.
My
देखिए एक बार.
item ছিল
দেখি,
10
দেখি, দেখি.
10 যশোর।
Thank you.
Release of the matter.
Oh, give me a second. 66 have taken. 66 of the month list. Oh, only, today is the month list date, no? 66 check to the. It is not within my determination. Ashun. Item number?
Number 21.
Not I will take care for the petition.
I am for the Asansol Durgapur Development Authority.
But they are the principal answering letter.
Who's for the state?
There is no relief against state, my lord.
Even then the state must appear. Mr. Dev, what is happening? You take up the matter with your new GP. In many cases, the state respondent state is not appearing. Even a lawyer is complaining that the office of the GP has refused to accept the notice in open court once. Yes. এই দাও ওটা কি দিচ্ছেন দাও কল্যাণ বাবু
The affidavit of service, my lord. All the respondents have been served.
what is your prayer, sir? Immediate correct the mutual mistake committed by
This relief is principally against the Asansol Durgapur Development Authority. I tell your lordship, first kindly take page 19 once.
19
19.
of the read petition.
Yes.
Have they filed a report?
No, my lord, it's appearing for the first time. And lordship, this is the matter, my lord. It is a at a premature stage. The petitioners were called for a hearing, show cause notice after show cause notice was issued because they didn't utilize the land. It was a embargo of 3 years in which they ought to have made a factory.
You made an allotment.
Allotment was made and
Allotment in the form of lease.
in a lease. It was executed in 2009 itself.
Yes,
so I
then?
think it's a premature lease. Because hearing was granted, thereafter they appeared, but the order has not yet been passed because there has been a change in the chief executive officer has been transferred and a new person has come. So without any order, they have come up with this writ petition.
Yes.
And now if my learned friend submits, then I'll.
So should I direct them to consider your representation
My lord,
or
difficulty-
conclude the hearing?
Now, difficulty lies, my lord. I have submitted my representation. They are yet to pass an order. That is their admitted stand. Now, pending this, my lord, what they have done, my lord, they have put this signboard in the property itself.
You are still in possession.
I am still in possession, but they are
What signboard may I see?
land belongs to Asansol Development. And materials are always all stacked there. I tell your lordship what has happened. I'll just give the brief facts, my lord.
Very good. Let me see.
I'll just give the brief facts, my lord.
Page number 19 you have referred, no?
Page 19. My lord, I have been given a factory land to install a blast furnace. In addition to that, my lord, I sought for a raw material yard. This is my prayer at page 19. My lord has found.
Yes,
Now,
sir.
pursuant, this is the
This
additional
you
land.
have successfully you have set up the factory of the allotted by such and such. Hello.
Yes. My lord will
Then
find
for
the subject.
improving the volume of we require additional land.
Additional land. This
So
is
then,
just
if additional land is allowed, we shall keep our raw materials as well as finished goods such land.
the scope of this writ petition is this additional land. So
That has been allotted or not allotted?
no, this has been allotted. I tell your lordship. Allotted.
No,
now
no.
We sought this
Land was allotted for setting up factory. Or additional land was also there.
additional land was also allotted.
Then
I tell you. Land is for setting up a factory. That is the main land. The additional land is for the purpose of constructing a raw material yard that we had sought for. That land was also allotted.
very good.
Now, your lordship would kindly takes their map at page 19. This map says
Page number 20.
page I stand corrected, my lord. Page 22. My lord will find plan showing the additional land earmarked for Messrs. Durgapur Metallics Limited stockyard area bounded in red. So it is for stockyard yard. My lord has found. And this
But red mark is not there.
My lord,
Red mark is not there.
it's not there, but it has been prepared. Is their document. The Asansol development.
Either as it may, what happened thereafter?
Now, my lord, therefore, this land was for the purpose of stockyard only. This
Yeah.
additional land. Now, my lord, they have issued a show cause notice upon me that my lord will find at page 44. There they are saying that I have not utilized this land. I have not made any construction in terms of the original lease deed. Now, my case before
Page
you,
number 44
page 44.
is a notice for cancellation.
Notice for cancellation. Third.
Directed to show cause. Very good.
Whereas
You are directed to show cause as to why deed of lease will not be determined.
Yes, my lord will kindly say on what ground. That is the third ground. Whereas the survey conducted by the office reveals that no development has been commenced over the demise plot within the stipulated period of deed of lease, which is as per the covenant papers to be 2 years. Now, my lord, this land was for the purpose of stockyard, not for setting up of any factory. So, my lord, I have stocked materials there, and since in the deed, my lord, it has been stated by them to be that the land should be used as a factory. Though in their map they have said that it should be utilized as a stockyard.
Then you are bound by the terms and conditions of the lease.
Now that is the difficulty, my lord. I made a representation before them. I say that this was all along being. I was assurance that this was.
Is it your case that the second deed of lease was executed under threat, coercion, misrepresentation,
My-
fraud?
It's not,
Then-
but I would say it's a mutual mistake. I would say it is a mutual mistake because from their document, which I have shown, their map, they are saying that this is for the.
Where is the
purpose of-
second deed of lease?
Second deed of lease, my lord, will find that
There is only one deed of lease. There is no second deed of lease. It was executed. Both parties applied mind, executed, and it's a concluded contract.
In respect of the additional allotment of additional land?
Yes.
They had, before the lease deed was executed, they had applied, they had said, no, this quantum of land is not adequate for us. And they applied for us. And it was for a
So by
quantum of,
executing a single deed of lease, two land was allotted.
they requested, it's at page number 23, they requested for 23.85 acres. And on their request, combining the entire amount of land, a single lease deed was executed.
Yes.
And this is a concluded contract which cannot be altered now.
Absolutely.
Now,
I will
page number
reply to their
23.
show cause.
yes, I have replied to that show cause.
Let them take a resolution, a decision.
Actually, as far as this show cause is concerned, we are bound to dispose it of. But as far as amendment of lease deed is concerned, there's a clear judgment of the Honorable Supreme Court that cannot be done under Article 226.
Absolutely. Yeah, you have to go before the civil court.
Lordship, if at all.
My lord, I tell you, lordship, my lord, only one factual part, my lord. My lord, the additional land, my lord, only one. deed. But that additional land, my lord, on two occasions I sought for land, so one deed.
Are it
but-
the mutual mistake? What is the mutual mistake, sir?
My lord, mutual mistake, my lord. My lord, mutual mistake relates to, my lord, since all along it was said, I was given to believe that it should be used for the purpose of stockyard. Now kindly takes their deed itself once. Kindly takes page 24. Here the deed start,
Page?
page 24. And the relevant page is at page 26.
Huh.
Yes. My lord will find the second line for a lease for the purpose of building a factory for stockyard yard. They have used the word factory for the purpose of stockyard yard unit. My case before the concerned authority that no factory was to be set up for this additional land. And my lord, which my learned senior friend, what my learned friend is saying, that there are two plots of land. Of course, there are two plots of land. Two plots of land in addition to my main factory unit. In my main factory unit, there is a separate lease. There I run the factory. In addition to that, my lord,
Go before the civil court.
This
Sorry.
was
My
never
lord,
this,
kindly grant
this
me
was
that-
never the case. This was never the case.
my lord, kindly.
You want to vary the terms of the contract in a writ petition.
My lord, that the prayer is there, but
This
the
was never the case.
representation I have made, let them consider the
In page
representation.
number 23, it has been made clear. They want to make a stockyard as well as the factory and want 23.85 acres. Accordingly, the lease was entered into. This is completely a new case. After they see that they are not being able to set up the factory, and
The party ওটা দিয়ে দিন ওগুলো।
Once again, I am before lordships to disturb your lordships, but they are the troublemaker. For these reasons, my lord, in order to shorten your lordship's valuable time, or the same.
But why you have pointed your finger to Mr. Dey? Mr. Dey was never a troublemaker.
Mr. Dey is absolute troublemaking. At least always for.
And in that case, you must invite the trouble, which is why you have made the trouble.
I like him very much. My old friend, no problem.
Give me a second, sir.
Yeah.
Is there any private respondent?
No, my lord.
Yes, Mr. Banerjee.
Now, my lord, kindly see.
The provision of 51, Rule 51 of the Act, that to file appeal before the judicial.
এটা খুচরো পয়েন্ট ছাড়
So point
না শোন আমি বলি আগে তারপর যত খুশি বল ওই ও তোকে শিখিয়ে দিয়েছি তো তুই বল ছাড় ওদের এই লোকটা এদের মামলা আমি অনেক করেছি কাইন্ডলি কাম টু কাইন্ডলি অর্ডার ওন অর্ডার ইটস নট সো ইজি সস্তায় কিস্তি মারিসনি কাইন্ডলি টেক ট্রাবল টু কাম এট পেজ 124 my lord's own order.
Page number 124.
সুপ্রিম কোর্ট 1000 ঘন্টা জাজমেন্ট দিয়েছে এখন আপিল দেখাচ্ছিস
Yes.
Have you also got my lord? One to four. Now the law is kindly by place my lord's own order. The report dated 8th April 2025 as submitted by the respondent 6th. So Mr. Dey, learned AGP appearing for the respondent state and its functionaries is taken up or taken on record. On behalf of the writ petitioner, exception to such report is also filed and the same is also taken on record. At the time of hearing, appearing for the behalf of the writ petitioner, at the very outset draws attention of this court to the judgment and order dated such and such as passed in terms of judge by a coordinate bench. Of
But
this court.
I direct them to pass a reasoned order.
I'm coming, my lord. Not only that, there is something more.
Very good.
Coordinate bench of this court is an earlier round of litigation. It is submitted by judge and judge that from the said judgment and order, judge it would reveal that the direction was passed upon the respondent 5, authority to pass a reasoned order after giving an opportunity of hearing to the writ petitioners. So every time all the courts, honorable courts, they are saying reasoned order. Then in this next limb of submissions, attention was drawn to the paragraph 26-27 of the instant writ petition. It is submitted, it has been stated by the writ petitioner on oath in the said two paragraphs that in utter violation of the judgment and orders and such, respondent number 5 did not conduct the hearing, and on the contrary, such hearing was conducted by the respondent 6, who has no authority to conduct such hearing pursuant to the judgment of the orders and such. It is further submitted that the order under challenge suffer from material irregularity as well as perversity, since the order under challenge has been passed by the respondent 5 authority, though he had not heard the writ petitioner and those coordinated by the respondent number 6. Every stage by irregularities. Anyway, it is further submitted that the order under challenge is also perverse in another aspect in view of the fact that the said order the respondent 5 authority placed his reliance upon a report dated such and such as submitted by the SDL, PLRO and PLS and such without giving a copy of same to the writ petitioner prior to passing of the order by the challenge. It is thus submitted that the cardinal principle of natural justice has not been followed since the writ petitioner has got no opportunity to controvert the said report as relied upon in the judgment. Mr. Dey, learned additional government pleader, in his usual fairness, is always fair, there's no doubt about it. In his usual fairness, submits.
You don't have you have no right to doubt that.
I like him very much as a cost of reputations. In his usual fairness, submits before this court. He's a very good fighter, you know. He was the secretary of the bar association. আমি একটু শুধু পিলিং দিয়ে দিতাম চলবে না অমুক তুসুক চন্ডী has started রণচন্ডী would in the event the Respondent 5 is directed to act in terms of the this is really fairness for this that in terms of the judgments by setting out aside the orders that which is the subject matter of challenge in the incident process. Always I expect that fairness will continue even in this case. on careful consideration of the entire materials as placed before this court. This court finds sufficient justification and sufficient answer appearing on behalf of the petitioner, basically the following grounds, namely, there is no denial on the part of the respondent authorities that the respondent 5 did not conduct the hearing as directed by the court in bench. Though the respondent 6 conducted the hearing, respondent 5 passed the order under challenge, which cannot be considered to be just and legal, and the same is considered in view of the court of absolute powers, and the respondent 5 has failed to follow the established principles of justice by not giving the answer. Very clear order. In view of such, this court thus finds sufficient merit in the instant petition. Accordingly, instant petition is allowed. Consequently, the order dated such and such passed as follows. Before parting with its court, further direct the Respondent 5 to himself conduct the hearing as directed by the court in bench of this court. The Respondent 5 is further directed to give an opportunity of hearing to the writ petitioner and or his legal representative, and thereafter shall pass a written order in writing and shall forthwith communicate the same to the petitioner, preferably by message. Now, paragraph 13. Liberty is given to the writ petitioner to file his written objection against the joint report dated sunset before the Respondent 5 prior to commencement of the hearing, and while passing the written order, Respondent 5 is directed to give the due adherence to the such written objection as would be filed on behalf of the petitioner. Let them show at least one line from this order that particular order is complied with. Kindly come to my written objection, which is very material. Substantive objection which was filed. Let them show one line from this order.
Page number?
Report is there, my lord. Report
Written submission.
134. In compliance with also directions with the blessings of the Honorable Court, I file this in details. 134 onwards.
Very good. Then
Nothing. I am reading this objection. Is there any whisper?
so without considering a written objection,
Yes.
order was passed.
Yes.
So what is the nature of order?
Nature of order, that application is rejected. My paper is rejected.
What application you have made?
My lord, there is a case. Kindly see, my lord. Parties entered into agreement. But the very vital clause was there, the force majeure, which is very material because it depends on the nature. So naturally, there is some incidents which prevent us to complete the job. Considering that aspect, there is in terms of the agreement, my lord, that if there is a force majeure, the time which is lost, that we add, that should be added in that original. It is not an extension.
In respect of a mining lease.
Yes.
For some reason or other, you could not perform the excavation work.
That is admitted position, force majeure. That they did not deny. The question is this, my lord. So
the district magistrate has passed an order.
yes. Now
And
they have
appeal lies
completely right.
before the commissioner.
I need not.
Appeal lies before whom? Commissioner.
I need not. For this reason, it is violation of the lawsuit directions. I need not go to anywhere. Let them first satisfy. They have completed the High Court's order. Why should I go to commissioner? My lord, the court's order has been violated. I could not understand the normal affairs. Merit, it is decided. My lord, direction to
Take
consider.
this point in the appeal. What is the
My lord,
debate
here,
about?
my lord, I am placing this manner because the violation of the lawsuit's order. I could have filed a contempt. I am not going to take the time. But why they are not? Earlier occasion, the same thing. My lord entertain. Instead of X, why pass the order? My lord should have said, no, Mr. Manager, go to appeal. For obvious reason, because court's order has not been complied with. When I got the order from Justice Subra Ghosh, there's a direction that Section 5 such will pass this order. After AVL and all the Supreme Court cases, my lord, well, there is a violation of natural justice. My lord, observe that. If there is a violation of natural justice, I need not go to anywhere. I must approach before the High Court. Law is very clear.
While passing the order impugned,
Yes.
now according to you, natural justice has been followed.
No. That's
You have,
obviously.
you have not given a chance of hearing.
Why is that? My objection has not been considered. This is more than that. The serious aspect.
A good ground for appeal.
That's why I say it is not a question of appeal. Since violation of the court's order is not been complied with, that's why I have come. Kindly reject my petition, taking the job, observing.
Mr. Banerjee, with due respect to your experience, there are two well-recognized exceptions to the doctrine of exhaustion of statutory remedies. First is when the proceedings are taken before the forum under the provisions of law which is ultra vires. It's not so. It is open to a party agreed thereby to move the High Court for quashing of the proceeding on the ground that they are incompetent without being a party, being obliged until those proceedings run their full course. So district magistrate is not the competent authority, is not your case. Secondly, the doctrine has no application when the impugn order has been made in violation of principle of natural justice.
Kindly come to that. That's why violation of natural is very.
So you have to establish that there was no that the district magistrate has not given any chance of hearing or present your case.
Kindly appreciate unless that's more than that violation of natural justice. When there is a my lord, this is not an unnecessary order. When my lord observation is very clear. If any written objection to be filed, that should be taken care of and should be heard.
Take that point in the appeal, sir.
My lord, this is a direction of your lordship, my lord. Why should I go to the appeal? The earlier occasion, the same thing was happened. Justice Supra Court directed Resolution 5 to consider Resolution 6 pass the order.
Come back tomorrow.
As your lordship.
কালকে এটা আইটেম নাম্বার 1 থাকবে।
No problem. I'll come tomorrow. না তোমার সুবিধা নেই সবকিছু নয়।
No, 2 p.m. I'm sorry.
I'll once the my observation is made.
Very good. Only not today.
Yes.
Tomorrow রাখুন at the top of the list. Under the heading fees motion.
Before rising, I am praying very short indulgence before your lordship.
Up to from 2 p.m. to 3 p.m. I will take up the motion matters.
Lordship,
Supplementary matter.
Well, my lord, I'll one thing, my lord. I'll come back at 2 p.m. I'll
2 p.m. You said they will come back at 2 p.m.
before rising, I am praying very short indulgence before your lordship.
No indulgence.
Due to the grave urgency, lordship, day after
Everybody has a
kindly, lordship. Day after tomorrow, my building will be demolished, lordship. Kindly, lordship, that's the urgency, lordship. Kindly, lordship, allow. I am not on that my building will not be demolished, lordship. I am on that, lordship. The opportunity of hearing should be given. If there is any unauthorized construction, building should be demolished. Only the opportunity of hearing should be given. Kindly, lordship, allow me.
I am for the my learned friend is requesting the
But I am appearing for the statement. But I only beseech my lord kindly extend it for a limited period, my lord.
again you will come, again you will disturb. Let it be extended.
I am appearing for the respondent, my lord. I shall not disturb your lordship. My learned friend is, my lord, seeking extension of interim order. It will, my lord, it will expire today. So your lordship can fix it, my lord, tomorrow.
আসুন on careful এটাতে তো মিস্টার ব্যানার্জি অ্যাপিয়ার করুন বলল, হ্যাঁ?
Yes. Now, my lord, this is continuing. My lord, your lordship will kindly consider paragraph 13 of your lordship's order. Liberty is given to the writ petitioner to file written objection against the joint report dated 11 December 2020 before the respondent number 5 prior to commencement of hearing, and while passing the reasoned order, the respondent number 5 is directed to give due adherence to such written objection as would be filed on behalf of the writ petitioner. My lord, this report, this joint report of 11 December 2020 was for the first time given to us in course of hearing before your lordship's court on the earlier round of litigation. Lordship, kindly recollect.
Now you have filed written objection now?
Yes. Now in my earlier writ petition, it is a specific case that report was not given to me. Now, my lord, in the earlier writ petition, my learned senior friend had submitted the copy of the report to us, and your lordship granted us liberty to file written objection prior to the hearing of the hearing taking place, and then the district magistrate was supposed to give due adherence to this written objection. Now, lordship will kindly consider. Lordship kindly takes up page 134, the written objection, where, my lord, it is a very detailed one. Written objection on behalf of the lessee petitioner filed in compliance with the solemn order dated 28 April 2025 passed by the Honorable Justice Partho Sarathy Sen against joint report dated 11 December 2020 of the SDLRO and BLRO. My lord, this was submitted before the district magistrate prior to hearing commenced, and in course of hearing, this was relied upon on behalf of the petitioner. Entirety was relied upon on behalf of the petitioner. We have a specific case. My lord, lordship will kindly consider. I'll take your lordship to the order passed by the district magistrate later on. But the district magistrate, he relied on the report of the BLRO. He has just put in all the points taken by in the inspection report. Now, my lord, against the inspection report, that is the reason why I had filed the written objection. That is the reason why your lordship granted me liberty. Now, my lord, in my written objection, I have taken the points point wise 1, 2, 3, 4, 5 point wise. I have taken my objection. Now, my lord, it was your lordship's specific direction that while hearing and while passing the order, he should have considered the written objection. That he has not done. Now, my lord, your lordship will kindly consider the order thereafter passed by the district magistrate starting at page 161 is, my lord, is after going through the lease agreement and prior to that, that report of the joint report of the BLR and SDLO has been relied upon. But, my lord, your lordship's specific direction, my lord, here in this type of cases, my lord, I could have again taken out a contempt application because this is in clear violation of your lordship's order. This is an admitted position that the impugned order does not take care of the written objection, does not even consider, not a single line is there.
Let me see.
Yes, page 161, lordship kindly sees.
162.
161.
161.
Yes. 161.
Yes.
Notice is duly served to the petitioner and service return is kept with case records which made part of the proceeding. The case record is put up for hearing today. Advocate Orijit De filed Hajira on behalf of SG Projects Limited. One authorized representative SG Projects Limited, Mr. Swanso, is also present in hearing. Hajira kept on case record, heard the advocate and also gone through the written notes of arguments. It appears that the SG Projects quoted highest bid amounting to rupees Swanso after participating in the competitive bidding on 23rd November 2017 video auction dated Swanso for granting of long-term mining lease for sand over the schedule of land mentioned above. After all statutory clearances, said lease deed was executed in favor of SG Projects Limited, authorized signatory Swanso. On the basis of application submitted by SG Projects Limited, issuance of challan was started from this date and the lessee was issued challans for 66,000 CFT of sand for the first time. After a joint raid program conducted on 11 December 2020 by the SDL and LRO Bishnupur and BL and LRO Patrashar over the sand block code Swanso, SG Projects Limited, a report was sent to the ADM, DLRO and Bakura, where it was reported that the lessee is using machinery like suction pump, filter, net machine and boat for extraction of sand from riverbed. Beside this, the lessee has extracted sand more than 3 meters from the existing level of the river, which is also harmful for the natural course of river. The lessee has also made a wooden bridge continued with long sand bridge come road inside the riverbed, obstructing free flow of river water. No demarcation pillars found around the periphery of the leasehold area. There are so many overloaded trucks found in the vicinity. There is no staff of the lessee found at his office of the interrogated. The above mentioned points clearly revealed that the illegal sand mining activities were being carried out by the lessee. On the basis of the said show cause notice was issued to the petitioner, that is lessee Vide memo number so dated 14th December 2020. A reply in this regard was submitted on 28th December 2020 by one authorized signatory of SG process, completely denying the fact of illegal mining. Although in the representation dated so, he admitted the fact of illegal mining and requested to allow him for sand mining after due consideration. Thereafter, another 2 prior letters in this regard was submitted by SG process, praying withdrawal of the suspension was so. After going through the lease deed, environmental clearance lot and other documents, it appears whereas in terms of clause 2 of the part 7 of the lease deed, the lessee shall at his or own expense erect and at all times maintain and repair boundary marks and pillars according to the demarcation shown in the plan annexed to the lease. Such marks and pillars shall be sufficiently clear of shrubs and other obstructions as to allow easy identification, and whereas in terms of clause 15 of the environmental clearance certificate, mining should be done only in areas stretch identified in the district level survey report suitable for mining and so certified by the subdivision level committee. Whereas in terms of clause 3 of the part 9 of the lease deed, enforcement by state government may be taken against the lessee against the breach of the lease conditions not being remedied within stipulated period of time. Whereas the replies representation submitted by the lessee from time to time appears to be contradictory, and where the statement of the advocate on behalf of the petition lessee during hearing doesn't justify the claims of legal mining. At present, the mining lease of the petitioner was expired on 23rd May 2023, and after the expiry of lease, there is no provision for extension of mining lease in existing rules so and West Bengal Minor Minerals Auction Rules 2016 and West Bengal Sand Mining Rules 2021. In addition, as per West Bengal Sand Mining Policy 2021, the state government has appointed the West Bengal Mineral Development and WBMDTCL as designated agency for governing excavation, transportation, storage, sale and consumption of sand as mentioned in Schedule so. In the said policy, it is clearly mentioned in Schedule so that in existing leases, the lease shall not be renewed and shall be automatically be resumed and vested with the state government upon expiry of such lease. The state government shall then lease the sand mines to WBMDTCL or any agency recommended by it. Besides this, in respect of letter of authorized signatory State Bank of India, the district Bakura released the 2 bank guarantees SG process amounting to so respectively. Intimation in this regard was communicated to that bank with a so memo. Accordingly, SG process collected the letter so. Hence, considering the facts and circumstances stated above, it is seen that the petitioner failed to comply with the provision laid down in the lease deed environmental clearance certificate, for which the environmental parameters might be adversely affected due to the illegal mining activities. In this context, there is no legitimate grounds on the basis of which the stoppage of mining operations will be revoked on the mining lease period will be extended further as per representation of the petitioner. Hence, reply representation submitted by the writ petitioner in show cause are not satisfactory. Thus, said replies representation are considered and disallowed. Therefore, the order dated 28th April 2025 of the Honorable High Court, Calcutta, in connection with WPA number so in matter SG projects has been duly complied with. Nothing.
So no endeavor to
Nothing.
deal with your written
Nothing.
objection.
Number 1, number 2, my lord. May I take my lord? This is the third round. First round, no plea was taken regarding appeal consciously. Second round, before your lordships, no plea was taken of appeal. Why? Because they know they have got a weak point. First thing, my lord, kindly see, is he says that well, there is no question of extension of lease. Total concept. I'll come to the later appeal, my lord. Kindly come to page 167.
167.
67.
2016 Yes, 2016 Mr. Babu.
Have you also got it in 167?
Yes. बस बस ठीक है चल लेना. Yes.
अच्छा भाई. Hold on.
Yes.
Kindly come to 170. This is the notification on which Reliance has been made. Kindly come to page 170.
70.
170.
Yes.
I, or 3, Roman 3, or at top. Have you got it, my lord? Transfer of existing mining leases. In existing leases, the lessee shall not renewed and shall automatically be resumed and vested with the state government upon extension of such lease. State government shall then lease and shall sell. This is not my case. When the Act says something to be shut down in some manner, authority cannot use of the power. Here, my lord, lease is expire as a matter of course. Then if I ask for renewal, certainly they'll jump up. Not this that. Now kindly come to force majeure. In your also earlier order, that is also mentioned. Anyway, that's why they didn't ask for any paper of appeal. They didn't take that plea. Force majeure যেখানটা আছে বাদ কর। Principle. That's why Justice Subra Ghosh, my lord, directed them. My lord also directed them. Page 79. Calicut page 79. Oh, my lord said, looking to something. Page 79, my lord.
Page 79 of the writ petition.
Yes. My lord, white, bottom, sorry.
Yes.
Clause 5, failure to fulfill the terms of the lease. Failure on the part of the lessee, lessees, to fulfill any of the terms and condition of the lease shall not give the state government any claim against the lessees to be deemed a breach of the lease if so far as the failure is considered by the state government to arise from force majeure. I could not due to corona. I paid the entire amount before taking the lease. Huge amount. Even 1/3 I couldn't complete it because it was totally closed. I cannot use at that time. So that amounts to force majeure. I asked not for extension, to add that period within my lease. It's not a replace renewal. It's not an extension. So justice goes after considering inter aspect. No, this is the case where we should go High Court to interfere. No plea was taken. Secondly, when in compliance of the justice goes order, the person order, my lord found the way it has been in details, way it has been done, that is not correct. What prevented them to take that plea that well, there is a provision of rapid for obvious reasons. If non-compliance of the court directions, if there is a violation of natural justice, certainly court can take that step. And my lord, kindly spare me. I'll come to the Supreme Court judgment. Today I've never thought. Third time they will take that frivolous plea. Since there is a provision appeal, why you are so afraid? What I'm asking for? Kindly direct him to consider you comply your lawsuit directions. Nothing more, nothing less. And kindly see my objection. This is notes of argument. At page 21.
Page 21.
My lord, the writ petition.
Yes.
All those points are taken. Not even a single point is taken into consideration. Then, though there is a directions. Nothing has been considered, in spite of also directions. And whatever I file in compliance with lordship's order. Had it been a case, my lord, there is no direction by a lordship. Certainly they may say, no. Is the appeal simpliciter, go and prefer an appeal. How they dare to, this is the third time that they are deviating. How is it? They must comply at least. And I am not asking anything more. So please direct them to consider in compliance with the lordship directions my objections. And that is the lordship desire. That's all. That we have filed, it is recorded. So appeal cannot stand in the way. As we know, my lord, at Previal International, all so many Supreme Court judgments, that is going in the wind. Nowadays, my lord, is very clear. because writ is a special power and which cannot be snatched, taking that frivolous plea when they are not getting any chance to argue. Then, well, there is a provision for appeal. So kindly dismiss the writ petitions. That cannot be done. It's a totally violation of natural justice. And if your lordship so desire, I'll bring to satisfy your lordship. Day after tomorrow, I'll come with all the judgment. I can ask your lordship.
Yes, Mr. De. What is the predicament on the part of the district magistrate to make a single observation, single line observation rather,
Yes.
in Mr.
sorry.
Banerjee, please take a seat.
তাহলে তুমি আসতেই পারতো।
Mr. What is the predicament of on the part of the district magistrate to make a single observation as to why he has not considered the written objection as filed by the writ petitioner?
I'm grateful. Nothing more, nothing.
No, that was not done.
পড়ে দেখ না, পড়ে
It was not. It was never dealt with.
There is no whisper.
বের করে দিচ্ছি একবার
বের করে দিচ্ছে, তোকে হেল্প করছে।
চলে গেল এখান থেকে শুরু।
একটা লাইন ওখান থেকে বার করতে
এই নিন, এখান থেকে শুরু
চারটা
হচ্ছে।
অর্ডারটা কমপ্লাই করবে না, আবার হেরে যেতে পারে। জাস্ট ম্যাটার।
District magistrate ought to have come to a finding
Yes.
that the written objection as filed by such and such is baseless. Matter ends.
Nothing in the written objections. What is that?
Take down. Yes. Yes, sir. Yes.
What is the discussion?
It is reply, not written objection. I am talking about written objection. I have permitted them to file written objection. Written objection has been.
নেই নেই নেই, আমি তোকে বলছি নেই। এইবার তো ফেয়ারনেসটা দেখা।
No, no, it is not there, sir. Take down.
Okay.
This
Time when I'll come, I'll cite on Supreme Court judgment that was delivered by Justice Madden, sitting with Justice Chakma, sitting with Chanduchud, senior Chanduchud. It's a nice judgment, but nowhere it can be said the power of the High Court under 26 is restricted that way. Only little bit slow. It depends. That's why my lord very nicely clarified why my lord interfere in this case. Merely because there is a that doesn't mean in all.
No, there was not a single aberrament.
No.
Hearing?
Public election.
Is there any private respondent, sir?
Yes, yes. I have filed the affidavit of service.
উনাদের মামলাটা কখনো আইটেম নাম্বার এইটা এইটা CPM তো অরিজিনাল সাইড ম্যাটার আছে. Your other side is here. If you are no, if possible, please call in. I can take up the matter.
There were two PM fixed matters, 678, 679. Possibly those will not be taken up. Those are marked in the list as 2 PM.
No, Mr. Banerjee.
And first.
If possible, please bring your other side, I can take up the matter. Yes.
After the filing of the writ petition, they have actually broken a part of my property, and therefore I have filed this supplementary affidavit. My lord, gist, my lord, the case is that I am the owner of a property about 17 decimals. The record of rights I have annexed at page 64 of my lord's brief. Now what happens?
Page number 64.
64 is the record of rights, which shows that I am the owner of about 17 decimals of a plot of land, which is the subject matter.
It is not a document of ownership.
At least possession.
Possession, that you may say.
Yes.
Your pleading is at page number, paragraph number 2.
Yes.
That you are the owner of the property.
Yes. Now, what
to the extent of 17 decimals.
To the extent of 70 decibels. My lord, some years back, on the southern side of that plot of land, a Kacha road was constructed with my consent.
Before my learner, there is a point of maintainability on my side portion. So far as the writ petition is concerned, my first response is premature.
Premature.
I have a judgment to support with. So if I may place a maintainable point, which is a point of demurrer, before my learned friend opens up the way.
If it is a point of maintainable.
Lordship, 3 pages I will show you, Lordship, thereafter I shall cite the judgment.
What is prayer?
Prayer, my lord.
My plot of land.
Page 14, my lord, of the writ petition.
Under Pradhan Mantri Sadak Yojana, they have taken up, usurped a portion of my land without acquiring it under section 44 of the Panchayat Act. No acquisition, nothing. Simply by
Why are you raising the point of maintainability, sir?
Lordship, may I
They
respectfully
have
invite?
given a consent.
Yes, no, not consent. Lordship, very innovative point of maintainability. If your Lordship may kindly come to page 71, the representation, the demand justice given to the authorities concerned. Page 71.
Yes.
Kindly, my lord, kindly sees the date of representation. If I may take this as the date of representation, that is 7th July 2025.
Where from will get that?
At page 75. The concluding part of the representation, my lord.
Yes.
7th July 2025, the representation. Although this is not the receipt copy, but if I may take this as sacrosanct. So 7th July 2025 representation before the jurisdictional authority. Now, if I may respectfully invite your lordship to come to page 19, the jurat of the affidavit. Kindly sees when was the, my lord, writ affirmed? 16th July in my copy. 16th July 2025.
Absolutely.
There is a pronouncement of this Honorable Court, a coordinate bench, of course. Kindly sees. It's a reported judgment. Lordship, can you read
Give
for
me
you?
a second.
Lordship, kindly sees, then.
Yes.
2017 SCC Online Cal 18746. 2017 SCC Online Cal 18746 by Justice Boshak. Kindly sees what it says, Lordship.
There is a statutory provision allowing a government officer a period of 2 months to take a decision from the date of receipt of a notice demanding justice.
So demand justice, if the representation is taken as demand for justice.
No, what is the provision?
7th July.
No, I want to say that there is a
Here my lord is invoking section 80 concept in the read principle applies. So 7th July representation, affirmation on 16th July, 60 days not completed, so premature. This is the judgment. Lordship may differ, Lordship.
But my lord,
अरे बाबा ये तो
facts
बहुत
of this
मुश्किल
case
है
that has happened is,
case of an urgency.
yes,
urgency clause, my lord, here is urgency clause. Lordship says that rule 26 may be dispensed with. That is with regard to service.
Code of civil procedure applies, but not to the fullest extent. The principle applies.
Honorable Single just says principle applies.
Now, what will happen in case of an urgency?
No, urgency is not.
Apprehension is that.
No,
and in my supplementary,
Sir, I will allow you to make I have not formed any opinion. Let me talk. Sir, in case a case has been made, the respondent authorities are acting in such a manner that the emergent interference of this court is necessary. Even then we have to court, they have to wait.
Lordship,
dangerous
kindly appreciate.
proposition.
Here, I am, my lord, just placing this judgment.
Very good. Any other?
And there is a representation on 7th July, affirmation 17.
Very
Now, if your lordship is not.
I understand your context.
Now, secondly, your lordship says imminent danger. Well, the second point, lordship kindly sees, second point, whether on apprehension, lordship can pass a mandamus. It's an apprehension from his document. From this writ petition, I can show you, your lordship.
I don't know what is the content of the representation.
Kindly sees page 74 first. The representation part. Again, I'm referring. My second point on maintainability. Whether mandamus can be passed on apprehension in a report. 74 kindly sees page 74. The part of the representation. Page 74, lordship. May I read out the relevant part? Lordship is at page 74. Kindly see second paragraph. রাস্তার কাজ শুরু হইয়াছে অতি শীঘ্রই আমাদের জায়গার উপর রাস্তা নির্মিত হইবে
Supplementary evidence has come.
lordship. Now here in paragraph 12 he says, paragraph 12 kindly sees paragraph 13, my lord. Paragraph 13 he says, I'll be on the supplementary affidavit, lordship. I shall deal with it.
Forcefully tried to say again. Forcefully tried to construct.
I'm on that.
Huh?
Oh my God.
I have annexed the photograph.
Lord,
They have broken it.
lordship, kindly sees paragraph 13 first of the writ petition. Because supplementary affidavit cannot supplant the main writ petition. It can supplement. New cause of action, new writ petition should come up. So kindly sees paragraph 13 also, what he says on oath in the main writ petition. Para 13, my lord, page 10, my lord. Kindly sees, my lord, that your petitioner state the respondent number 10 is a contractor under the scheme of so and so, and is trying to threat the petitioner that they will demolish the permanent boundary wall. So now in the supplementary affidavit, they are trying to supplement this cause of action by saying tried to, as your lordship, my lord, has been harping upon. Now, my lord, if so far as this writ petition cause of action of this writ petition is concerned, it is merely on apprehension. Now, if they say that some demolition has taken place, it's a new cause of action they should come up. At least this writ petition is not maintainable. On apprehension, my lord, no writ lies. There is a division bench judgment of our Honorable High Court. Kindly sees para 11. It's a division bench judgment. No article 226 on mere apprehension. Kindly sees, my lord. Shaib.
Hey, Dingo.
My lord, may I respectfully invite your lordship, my lord, to paragraph 11 straight. Para 11, my lord. My lord, may I respectfully invite your lordship, the last, my lord. Third line, last 3 lines, my lord, at page, my lord, at paragraph 11. The sentence starts with, my lord, here in the present case. Lordship got the sentence? Here in the present case, this court has been moved merely on an apprehension. Such an apprehension is that an order of detention may have, it was under detention, have been against the petitioner, and further, next page, lordship, that such an order may not have been bona fide and in accordance with law. The principle laid down by the Supreme Court is based on the basic assumption that there must be some reasonable grounds to support the alleged threat, and the court can satisfy itself of the impending threat with reference to the fact constituting the grounds. That principle cannot be extended to cover a case where on a mere apprehension in the mind of a citizen, he can invoke the jurisdiction of this court and obtain an anticipatory relief. It is not a case where any law having been promulgated or any particular statutory order having been made, there is imminent likelihood of such law or order infringing or affecting the citizen's right. All that the petitioner makes out in this application under Article 226 of the Constitution is on an apprehension which may as well turn out to be misapprehension. He is apprehending an order of which he is not sure. He is further apprehending that such an order would not be bona fide in accordance with law. All this is really a speculation. So by supplementary affidavit, if he is trying to demonstrate the photographs, it's a new cause of action. He may come out. So far as this writ petition is concerned, my lord, my respectful submission, my lord, it's a mere apprehension, lordship. This writ petition, I'm not on the separate cause of action.
Very good, sir.
On maintainable point,
Very
lordship.
good. What is your, come to the merit,
Yes. The merits of the case.
including the point of maintenance.
Yes. Very simple, my lord. My plot of land, it cannot be usurped by the state even for public purpose without acquiring it. This is the paramount point. Now, as far as the point of demurrer is concerned, my lord's cannot be helpless. In this case, what has happened? I have in the writ petition upon threats, of course there was apprehension, but after I filed the writ petition, they actually demolished a part of my structure, which I have canvassed before my lord through the supplementary affidavit. The pictures are the best proof of it. Now, a citizen cannot be tricked in this manner. This is not fight between two private parties. It is the state. It has to be holier than thou.
There is a private respondent.
No, with this particular cause of action, private respondent has been made party because
Respondent 12.
his property is on the other side of the alleged pathway. But he would not have grievance. I do not have a grievance against him. My grievance is against the state only.
So what is your prayer then?
That they have usurped my property. My right to property has been infringed. They have usurped my space without acquiring it. Therefore, my detailed representation that I have made is to be considered in accordance with law.
Take down.
And my lord, Justice Shamapti Chatterjee, as a lordship then was, had passed a similar kind of a situation, has passed an section 44 of the Panchayat Act.
Panchayat Act lordship then does not have the determination group 5.
The land matter.
Take down. absolute high-handedness, and I have not passed any order for initiating, Mr. Das, I have not passed any order for initiating a valid acquisition process, because under that scheme there is no such provision. They will reconstruct and they will pay you the cost.
Since the lordship has not been called for affidavit, lordship.
No, sir, I will not
have the, my lord, opportunity to rebut, my lord.
challenge a urgent Xerox certified copy.
And my lord, this respondent 12 will not be involved in the process.
You are not giving protection to your citizens, sir. You are not giving protection to your citizen.
No, my lord, whether
During the
demolition,
pendency of a writ petition, you have you allowed
whether the
No, sir.
demolition has been done during pendency or after, my lord, that was to be ascertained, my lord. Kindly appreciate.
Very good, sir. If it is not demolished in accordance with law, you don't pay.
Today the supplementary affidavit has
No, sir, nothing. Not at all. I will not incorporate a single word. Call the next matter. Original side, Achana?
Lordship, the respondent 12 will not be involved in the process.
Very good. Service has been effected.
Yes, sure.
Tomorrow, sir. It's too late. The writ petitioner.
My lord, item number 8.
It is item number 8. Tomorrow at the top.
My lord, tomorrow at 12 p.m. the demolition will take place, my lord. Tomorrow at 12 p.m.
Then I am to take it.
My lord, I have come up against the order passed by the appellate authority, the district magistrate under the State Highway Act, my lord. My lord, kindly come to page 27, my lord. It's the order passed by the SDO.
Sir, give me a second, sir.
My lord.
Yes, sir. So, sir, button your coat.
My lord.
Yeah, appearing before the High Court without buttoning your coat.
Sorry, my lord. My lord, kindly come at page 27. It is the order passed by the SDO, my lord. My lord, the petitioner is the owner of the plot of land being LR plot number 1948, my lord. 1948, and the private respondent is also owner of a portion of land.
Served upon the private respondent.
Yes, my lord.
Oh, you are appearing, I see.
Private respondent, my lord.
I'm sorry, will you repeat your submission once?
My lord, the petitioner is the owner of plot number 1948. My lord, the private respondent is also owner of a portion of land of 1948, my lord. My lord, I am in possession of the land. I am in possession of the land since, my lord, 1991, my lord.
So remain in possession. Why have encroached?
No, my lord, I have not encroached, my lord.
Then?
My lord, the private respondent purchased the plot of land. It is clear from the representation, my lord, at page 31, my lord. Page 31, this representation. Kindly come to para 2, my lord. রায়পুর মাদ্রাসা কমিটি মাদ্রাসার ঘর করার জন্য আমার পাশের ও দাগের জায়গা 208 সালে ক্রয় করে তারপর 2014 সালে জবির হোসেন, দ্যাট ইজ দ্য প্রাইভেট রেসপন্ডেন্ট, মাদ্রাসার কাজ হতে পাড়ার বাড়িতে যাওয়ার জন্য সাচেন্সের জায়গা আমার বাড়ির প্রাচীরের পাশে ও ওই ঘরের পিছনে খালের পাড়ে বাঁকা করে কিনে কাঠের কালভার্ট তৈরি করে 5 বছর ধরে দ্বিতীয় রাস্তা হিসেবে যাতায়াত করে মাই লর্ড। মানে he has complained about smooth ingress and egress, and he is having a smooth ingress through the culvert, my lord. My lord, then kindly come to page 32, my lord. Page 32, paragraph 6. 19/12/2024 স্পট ইনকোয়ারির সময় বিএলআরও অন্যান্য অফিসিয়ালরা প্রথম জবির হোসেনকে দেওয়া মাদ্রাসা বন্ধ রাস্তার হদিশ পেলেও পরে চাপে অন্য কারণে এই রাস্তার ব্যাপারটা এড়িয়ে নুরুল হাসানের ঘরে 8 ফুট ভাঙার সিদ্ধান্ত নেয় বলে মনে হলো। যাতায়াতের
You are Nurul Hasan.
My lord, all along there was a land for smooth ingress and egress of the private respondent. My lord, then my lord, the madrasa, the said madrasa who sold the property to the private respondent disputed the possession because of erroneous resolution adopted in madrasa and lodged a criminal proceedings against the private respondent. And thereafter, after the complaint, kindly come to page 27. The SDO passed the order dated 20th February 2025, my lord.
Demarcation was done.
Demarcation was not properly done. That is my contention, my lord. Demarcation was not properly done. And it is evident from page 29.
You participated in the demarcation.
Yes. I participated in the demarcation. I made my contention that was not given any cognizance, my lord.
Where is the wrong?
My lord, kindly come to page 29, my lord.
Huh.
The representative of Raipur Ismailia Madrasa submitted that Sheikh Jobir Hossain has wrongly executed an alleged deed being 00037 in the year 2014 by forgery of the meeting resolution held on 18/4/2013 by the Madrasa committee. And subsequently, the said Madrasa has lodged an FIR before the Nodagali PS. My lord, both a suit and the criminal proceedings are pending, my lord, and they have made a complaint regarding obstruction. All along, my lord, I was occupying the said land. There was no scope for entrance from that particular point, my lord, and that's why he has constructed a wooden culvert on his own. My lord, and without giving any consideration, my lord, regarding these things, the SDO
Sir,
passed
straightway come to the last paragraph of paragraph page number 29.
29.
Yes, sir. Please.
The said report was forwarded by the BLN LRO, Boj 2, white memo number such and such, along with a sketch map demarcating the extent of encroachment of an area of 184 square feet, which is used as shop and falls under LR plot number 1792. My lord, my contention is that this demarcation was not properly done. I have my shop
Have you
room.
taken this point in your memo appeal?
In the writ petition, there's not a single line saying that
Huh?
the demarcation is incorrect.
Then
He has to not base his claim on the writ petition.
absolutely.
No, let him show me not from the writ petition that he has challenged.
Very good. Have you taken this point in your memo appeal?
No, my lord.
Take down. If you sir open your mouth, it may go against you, sir. The subject matter.
urgent matter. I beg to put on to mention at this juncture, my lord.
Court
My
is,
lord, please
the
to.
court is convinced not to be convinced for taking any.
No, my lord. My lord,
concerning
please,
matter.
please.
Mr. Chatterjee, please come.
My lord, please to fix this matter at 10:30 on last Tuesday, my lord. It is not.
It will come, sir.
It's extremely urgent matter, my lord. Can it be, my lord?
We have to say you any.
My lord, please to fix this matter.
Yes, sir. I'm appealing for the petition in this matter. Hopefully, my lord, next week. My lord, probably almost done, my lord. Few factual back. No, I'm not repeating. I'm not at all repeating. My lord, kindly takes up, my lord, the opposition.
If you want to add anything, don't repeat, sir. I'm
Adding.
very good, sir.
On the previous submission, my lord, I'm adding to that submission.
Give me a second. Yes, sir.
My lord, kindly takes up the opposition by the KMDA. My lord, here I just wish to show, my lord, the stand of the state and the KMDA remains the same to the extent that they only aver in their pleadings paragraph 6 of the opposition.
Paragraph 6.
Paragraph 6 and my lord, paragraph 4C. 4C, my lord, kindly take the
Affidavit opposition of KMDA.
paragraph 4C first, my lord.
Yes.
Now, my lord, KMD also states, my lord, in line with state that the land in question being such and such was acquired in full for an area of measuring such and such, respectively in LA case number such and such by the state of West Bengal at the instance of answering respondent authority, being the KMDA for public purpose with construction of Eastern Metropolitan Bypass. Notice by such and such was issued under section 41A West Bengal Land Acquisition and Requisition Act, was duly published in Calcutta Gazette on 17/10/1974. Possession of the notified land was handed over by the acquiring authority to KMD on 18/12/1973 as KMD is the requiring authority. So, my lord, they are absolutely both the authorities are silent, my lord, on the, my lord, requirement of section 3, which has not been done.
That you have stated, sir, on
My
the
lord,
last
adding.
occasion. Which is why I don't waste time, Mr.
No.
Chatterjee. Time is
So,
very
my lord, I'm
precious.
quickly, my lord, both these affidavits, my lord, filed by them are, my lord, on that count.
No whisper about 3-1.
Yes.
No notice, no whisper about section 3 of Act 1 of 1894.
1948.
1948, Act 2. I'm sorry. Thank you. 1948. It is a 4 and 6 in I'm sorry. So there was no requisition.
No requisition. Now, my lord, the last point which I on factually, my lord, I want to indicate, my lord, with regard to the, my lord, the land in question which they say. Now, my lord, from the I have annexed record of rights, my lord, they have also annexed record of rights. My lord, in their record of rights, they allege that our record of rights mismatch with their record of rights. To the extent, my lord, of the name of the persons appearing in the record of rights. Now, my lord, if my lord takes up the state's opposition for once, my lord, I indicate the difference here.
Yes.
My lord, page 16, the record of rights which they annex. My lord, kindly marks the date. My lord, this is obtained in 2000. Certified copy obtained by them in 2000, probably. My lord, 2K it's written, my lord, underneath on the first page of 16. 16, my lord, bottom, my lord, certified copy. My lord, 111.
This is LRR or?
This is RS, Revenue Settlement Report.
RSRR.
Yes, RS. Now, interestingly, my lord, what is to be looked into is, my lord, the plot involved is, my lord has noted the DAG number, but Khotian number on the last occasion I've indicated. Kindly see stop Khotian number 689. My lord has seen that?
Khotian number 689.
Now, my lord, in the lower bottom, in that just the column beneath, my lord, the first row, Khotian number my bata. So, my lord, this Khotian is divided
by bata.
By bata. So they are concerned with this bata dag, if at all. And in this bata dag, they find the name of these persons. And they say the entire plot has been acquired. Now, if my lord turns on.
No, Mr. Chair, what is your contention?
My contention is, my lord.
There is a bata Khotian.
There is a bata Khotian. Now, when they are making payment, now I'm on the question of, my lord, payment, my lord, making award, my lord, within due time. Now, my lord, what they are doing is, my lord, here, first of all, violation of section 3. Then, my lord, when they have annexed the award sheet, my lord, with this opposition, I will show, relying upon this RS, that they are making in respect of the bata dags. That too not within time. Now, what happens, my lord?
Just a minute, sir. So far as these RSR is concerned, you told about some names.
Yes, this.
What does it mean?
Names.
What do you want to say, rather?
My lord, this means that in the record of rights, they themselves have corrected and put in certain names. My lord, when we don't know. But, my lord, I am on the concern of the bata dag. So, my lord, when they acquired, they say they acquired the entire plot in jail number 13, Mouja Kosba. Now, when they refer to the dags, my lord, they refer to the dags in Khotian number 689.
Right.
But, my lord, they are in bata dag. Kindly see, my lord, kindly turns over the page 17. My lord will find one plot, the relevant dag, 3777. So, my lord, a Khotian is now been segregated in all. It's not in full. That's why, my lord, I will show, apropos the notification of section 4. If my lord takes up the section 4, page 14 once, my lord, very interesting, my lord, which is going beyond the, my lord, form which is given in the act. My lord will see revisional survey plot in part, not in full.
You are referring which portion?
Lord, page 15 of the 1441 notice. My lord will see this is in part, not in full.
So according to you, if at all any acquisition has been done, that is in respect of a bata plot.
Yes, part plot.
This is a bata plot.
Bata plot. Firstly, secondly, my lord, I will show.
No, you come to the same page number 15.
Yes. They
777 entire.
And they write entire. But on the top, my lord, this is going by the, my lord, form, against the form. My lord, there is a specified form, my lord, under the act. If they acquire in plot, in part, they have to specify portion. If they acquire in full, it doesn't require specification of specific portions. They can name the plot numbers. But that's it.
They have stated the entire.
They have stated entire. But they are not going by, my lord, with this record, their RS records are not telling. When they are making payment to these persons who are recorded in the bata plot. this my lord will find the names. My lord, in the award sheet, my lord will find the similar names. Those are recorded in the Bata plots. My lord, this is my contention. My lord, second, my lord kindly turns over.
No, Mr. Chatterjee, I'm sorry. As of now, I'm not very clear.
No, my lord,
So
then
far,
kindly turns to page 20.
just
My
a
lord,
minute.
I make clear, my lord, from page 20.
Very good, very good. Yes, sir.
My lord, Khotian number, my lord, will find top 2416.
Yes.
My lord, this Khotian number, my lord, will not find with respect to our plot. But my lord, in the lower portion, lower column, my lord will find 1142 Nongmong Hoite Khondo. My lord has found that Khondo. So, my lord, it's a part. Now find the name, my lord, Nagendranath Rai, Dinendranath Rai. Now, my lord, kindly turns over to the award serial which they have annexed to this plot.
The 1142 is what?
My lord, this is exactly, my lord. Kindly turns to now. My lord, by looking at the page, I will make it clear. Kindly turns to page 26A or my lord 26, whichever. 26A is a typed copy.
Very good. 26A.
A. Now, my lord finds they refer to Khotian number 2416. 2416 to 2418. So, my lord, this is a Khondo, and my lord will find this Nagendranath Rai, Dinonath Rai, and my lord Monmotonath Rai. They cut the names and they put Kalpana Mitro. And this plot is with respect to Dag number, my lord will find below 31 decimals in respect of 3775 entire. Type version just after Kalpana Mitro, the entire value of 0.31.
No, where from will get the plot number?
My lord, they have written in type version, my lord will find plot number 3775 bracket E 26A. My lord, just after Kalpana Mitro.
Srimati Kalpana Mitra, wife of Nonigopal Mitra
Yes.
address.
Dhakuria, such and such. Thereafter, the entire land value of 0.31 decimals. My lord,
Oh, plot number. Sorry. Thank you. Plot number 37775E. E means entire.
So, my lord, in Khondo, Nagendra Rai is recorded, but they refer to entire plot at the time of my lord awarding. My lord, kindly marks this. My lord, they create a Khondo plot of 2416 in Khotian. And they record name of persons in Khondo plot. My lord, otherwise, the entire plot is in Khotian. 1152. My lord, when it was not Khondo, my lord, the Khotian was, my lord, Khotian means Khata was 1152. My lord, after the plots were divided, my lord, it created a
Hondo, I will
and
get
separate
page number
Khata was
20.
opened. My lord,
Hondo, I will getting from
page
20.
20. So they are opening different khatas, means Khotian. Separate khatas are now being opened.
Give me some time. Four, two, 6A.
And my lord, the reference of 1152 my lord, of the entire
Mr. Chatterjee, if we read page number 15,
15, yes, my lord,
and 15 and page number 17.
17.
Yes, my
and
lord.
26
26.
A.
26A, my lord.
We find similarity of plot numbers.
My lord, 16 is with respect to Khotiam number 689 means plot number would be, my
No,
lord,
no, sir.
3777.
15 is the RS survey number. It contains 3777.
Yes, 3777. Yes, yes. It
Now
contains.
you come to page number 17, which is a continuation of page number 16.
Yes.
You find the 3777 Sali.
Yes, yes.
Now, if you come to 26A,
26A.
enter land value of such and such was given towards acquisition.
No, my lord, calculated.
Huh?
Calculated. My lord, given on 82. My lord, beside that, my lord will find white check number, this 21,882 on the top. And in the bottom also, my lord, paid the awarded amount of rupees such and such to Sri R.N. Chakraborty, Advocate Alipur, such and such. So 82, they have paid it. All along.
I am not on that, Mr. Chatterjee. If I look to the 15, 16, 17,
yes,
and 26A,
yes,
we find a chronology of events.
Yes, my lord, for the moment, yes.
For the moment, yes. Right? I don't admit.
Yes.
I'm just for the.
Yes, for the moment, yes.
Then how do you relate page number 24, 1142 Nong Khondo? That I cannot understand.
Yes, I'm just relating. My lord, kindly remember 3 plots: 3777, 3775, 3788.
Absolutely.
3777 is of Khotian 689. From his RS record, my RS record, it's 689 Khotian. There is no dispute. Now, my lord, in the side by my lord has seen an opening of an Bata plot. My lord, forget it for the moment, Bata plot. Now, in respect of 3775, which I relate to, my lord, page 26A, my lord, that refers to creation of a condo. My lord, separate khata has been opened. Recording name of few person. My lord, if a plot, my lord knows, my lord, in Mouja, there is jail number, there is Toji number, and a Khotian. My lord, when we refer to a plot, we refer to in which khata. So it's Khotian. And then if we draw back, then it's the king, my lord, Jamindar's Toji. Then, my lord, jail. So, my lord, in this reference, my lord, every plot has reference to a Khotian. So, when I take plot number, my lord, 3775, I refer to Khotian number 1152. But, my lord, if somebody else tomorrow I partition the property or mutate the property separately in my separate name, then, my lord, I open a separate khata. Or, my lord, in the same Khotian, I open Bata Dag. If I transfer, no question of Bata Dag, but a separate khata is being opened. But in partition, my lord, Bata Dags are being created.
That is the concept of present days. One person, one Khotian.
One person, one.
But no, it was not there when RS was given.
Exactly, my lord. This is where the falsification appears. My lord, they did that. They are opening khatas. Khondo means, my lord, they are parting the Khotian. And, my lord, that's why the Khotian number is mismatching.
Khondo Khotian or a Bata Khotian, there is no concept of Bata Khotian. It's a Bata plot.
My lord, if I take it, my lord, 2816 Khotian doesn't relate to plot number, my lord, 3775. If I may put it that way.
No, Mr. Chatterjee. In one Khotian, a Khotian may contain several plot.
Kindly takes up page 20. 1 second, my lord. Why I say so? 1 second. My lord, in after 2416, my lord will find Montobbo. My lord has found Montobbo, my lord.
21.
2020. My lord will find in Bengali written the Khotian number 1152 is written.
Samil Niskor.
Samil Niskor. So, my lord, this is the original Khotian 1152. Then, my lord, this Khondo is being created.
মন্তব্য সামিল নিষ্কর 1152 নম্বর সহ।
Number show. So, my lord, original Khotian number 1152. That my lord will also find, my lord, in the 44-2A proceeding. Reference to 1152. In this jail. My lord, I have referred to that 44-2A proceeding in my reply.
In your reply, no?
Yes, in my reply to the states. My lord, page 24. My lord, the second do 1152 834 689.
Page number
24, my lord. The second do, my lord, in the middle.
1152 834 and 689.
Yes.
So though no, on the last occasion you said that these three Khotians, the relevant three plots were recorded in these Khotians.
Yes.
That is what you were
That is admitted. They also annex this record with respect to these three plots. My lord will find the similar Khotian numbers here.
Now you want to say that from original Khotian 2416 a Khondo Khotian was prepared.
From original Khotian number 1152, Khondo Khotian 2416 is prepared.
Oh, Khondo Khotian 2416 was prepared,
and
which contains a butter plot.
Yes.
And over which compensation has been disbursed.
Compensation has been disbursed, that too, my lord, after lapse of, my lord, 3 years. My contention is. That, my lord, will find, my lord, from the date when the award was given. Now, my lord, if my lord 626.
Wait for some time. And from Khondo Khotian, compensation was disbursed in respect of which plot of land?
My lord, this plot refers to, my lord, Khondo Khotian
3775.
3775.
So which is your plot?
Which is my plot.
Huh.
But, my lord, they create a Khondo Khotian and pay some third party the compensation saying that we have acquired. Now, my lord, I say, my lord, this creation of Khondo Khotian, when you name the person in the Khondo Khotian, then you say that you pay to that person in Khondo Khotian. Admittedly, then the remaining part of the Khotian or the plot of land, you have not touched even, or my lord, has not gone into.
Mr. Chatterjee, I fail to understand one thing. For the sake of argument, if I accept your contention that a Khondo Khotian is prepared from original Khotian number 1152, how do you demonstrate that in respect of plot number 3775, a portion has been acquired and compensation has been disbursed? That is not your case.
I'm telling you. Suppose, my lord, I say, my lord, at the one hand, I say, my lord, I acquire entire 31 decimal. Now, my lord, if I say I acquire 31 decimal, then, my lord, I put all interested person of that 31 decimal on notice.
Absolutely.
Now, my lord, on your record of rights, you reflect that there is a Khondo created. And in Khondo,
there are 4 persons. My lord, I keep my eyes shut on the remaining plot. I bring those persons in the condo and I say I put them on notice. When my record speaks otherwise.
Chatterjee, compensation is not paid on the basis of Khotian.
No.
It is disbursed on the basis of the acquired plot of land.
Absolutely. Then, my lord, kindly turns to page 21 then. 21 says these persons are recorded for 15 decimals of land. What is the entire?
Page number 26 or 26A indicates entire land value of 0.31 decibel of Sali land in respect of plot number 3775 within bracket entire with interest plus RC. If it is taken on face value, it says that disbursement of compensation for acquisition of land of plot number 3775 has been disbursed.
Yes.
So what is the difference in that this plot is in the main Khotian or in the Khondo Khotian?
Milord, it makes a difference when I look at page 21 because it refers to, Milord, 15 decimals of land. Milord, I write something on paper and when I refer to a Khotian,
21 decimal,
15 decimal, 3775.
দাগের মধ্যে অত্র সত্ত্বের অংশের জমির পরিমাণ।
Yes, out of 31, 15 decimal. Milord, I say in Khondo.
15 decimal is the land occupied by the Rayat.
15
And
decimal
31 decimal is the total land.
Total land,
And
absolutely.
if you come to page number 26A, they say they disburse compensation for the entire land.
Yes. Milord, if I take on the face value even, Milord, I am saying, Milord, I have paying for the entire value. But I am calling upon a person who is, Milord, 15 decimals owner. I am on that point. Milord, I am 50 decimal owner from their record. They know. These rayas are only for 15 decimal. I acquired the 31 decimal. Then where are the other owners of 15 decimal?
These are the submission from the bar.
Milord, I am relying upon his record. I am not even touching my record.
Not even in your reply.
Milord, I am on that point. Milord, they have acted in such a manner.
I understand your contention. That on comparative study of page number 20 and 21 and 26A, if Nogendranath Rai is the owner of the 15 decimal out of 31 decimal, then Kalpana Moitra ought to have obtained compensation for 15 decimal, but not in respect of 31 decimal. So here lies the discrepancy.
Yes.
If your lordship kindly come on page 21.
I will hear you, sir. I will hear you.
My lord, confusing is that 31 is my lord already in 3 record of rights.
Page number?
Page number 21, that is the page number 20, Nogendranath Rai, that is 15.
15.
Then my lord, page number 23, the 22, Manmatanath Rai, 8. Page 23.
Page number 22, Monmouth Rai, how much decimal?
8.
What from you get that?
Page 23.
8 decimal, yes.
And my lord, page 25, page 24 and 25, my lord,
Another 8 decimal. Tulsichand Rai.
that means 31,
Order
15
16
and 16 and 15.
16 আর 15 yes, 31. Mr. Chatterjee,
Yes, my
then
lord.
how do you say that?
Now, my lord.
You come ready. I am not. You are not properly ready, I believe.
No, my lord, I'm just, my lord, indicating, my lord decides, my lord, because this is, I tell your lordship, my lord, this creation, my lord, therefore admitting, my lord, these plots were divided and separate Khotian were opened. There is no doubt. My lord kindly takes that on the face value. My lord, I accept page 22, 23. My lord, separate Khotians were opened in that dark. Now, my lord, if 4 persons, my lord, for whom
Just a minute. Yes.
No, I will not travel. I assure my lord, I will not travel beyond.
Let him travel, sir. I will consider.
Now, my lord, assuming, my lord, what he says is correct, my lord. My lord, there are time limit.
Probably you will consume the whole day.
I will continue this factual aspect. Next day, I will show only, my lord, decisions.
Again next day.
My lord, decisions are to be shown and
Oh,
provisions.
then after coming back from Jalpaiguri. Not now.
But tomorrow, my lord is leaving 11th.
I have to write judgment.
I will take half an hour. Not more than half an hour.
You will not be able to conclude today.
My lord, I have to rely upon decisions, my lord,
Then, sir,
and my lord, the provisions.
then come back after vacation. After returning from circuit.
Yes.
Impossible.
Everything, my lord, will be again.
No, difficulty is this. I'm telling Mr. Talu, there's a practical difficulty. Probably
That's the biggest question.
Mr. Chatterjee, I'm telling you. In order to dispose of this matter, I took this file to my home, and yesterday night I have gone through it, so that I can come ready. But you are saying that you will take another day.
Only to this. I put this question. One question.
Today is Monday. It will take tomorrow.
Tomorrow, half an hour, end. My submissions would be over.
No, then it will not be.
I will cite
They will
certain
take some time.
decisions. I come back.
Come back after. Let me come back after Jalpaiguri certificate. Then it will be given priority. I'm telling you. We are in the month of August. No, wait. On 26th August at 3 p.m.
I have no issue.
26th August.
Yes. Sir, kindly gives me half an hour. That's it.
No. After 26th August, I don't have any problem. I will remain in the principal bench. No. Had Mr. Chatterjee consecutive dates.
Yes.
No. আবার কি হলো?
Half minute, Lordship. Then I'll go back to my home at Purulia. Lordship, kindly, this my
not possible.
Lordship, only half minute. Listen, please. I came from Purulia.
না রিট পিটিশন ডিসপোজ অফ হয়ে গেছে, কন্টেম্পট অ্যাপ্লিকেশন হয়ে গেছে, আবার কি?
Na contempt petition. My matter is that just I can't go to upper bench against the contempt petition. That's why I file a writ petition. That order was unfortunately passed beyond the rules. That's why I again apply. Lordship, only listen me for.
Wait for your turn.
Matter is of
Wait for your turn.
1998.
Wait for your turn.
Supreme Court order is not complied till there. Only for 15 minutes time, Lordship, kindly grant
not possible
within this week, please, Lordship.